County Sheriff, which is Robert Schutte.
Okay. As to Summit County Sheriff versus Robert Schutte, and I know, Mr. Gallick, you've heard this before because you were here on a different case, appeal involving Mr. Schutte, but just for everyone's benefit, I want to put on the record, when I was in common pleas court, a case was filed by Mr. Schutte, and that just happened to be that particular case. It was a pro se case filed by Mr. Schutte. It was not the exact claims, but at least the start of these claims. My only involvement in that case was to grant Mr. Schutte's motion to voluntarily dismiss. As we know, he didn't have to move to do that, but he did so move, and I granted the motion. That was the end of my involvement, but I felt it necessary and appropriate to put that on the record and to ask both sides if either of you had any problems with me sitting on this. Mr. Gallup, go ahead, Nancy.
You're just a little deja vu, because, but obviously to make, to say, it sounds like your involvement was very, very minimal. I mean, as you say, you really didn't even, you don't grant a 41A, you just sort of acknowledge that he filed it, so your involvement in the material facts of this case have been essentially nothing.
That means you had no problem?
I have no problem hearing this appeal, Your Honor.
All right, Attorney Sims.
And for the same reasons set forth by Attorney Gallick, the county defendants also do not have a problem with you presiding over this appeal.
All right, thank you.
Thank you both. Each party will have 15 minutes in which to present the case this morning. Help me to retain up to 5 minutes for rebuttal. If you comment, you want to retain some of that time, let me know. I'm keeping track of the clock, and we'll keep you apprised of the passage of time. We are being visually and audibly recorded to be posted online, so please try to remain behind the podium. Please try to remain behind the podium as much as possible. We have read your briefs, and we're ready to proceed.
I would ask for 5 minutes in rebuttal, and may it please the court, opposing counsel Donald Gallick on behalf of plaintiff appellant Robert Schutte. This is the second time this exact case has been in front of the court. I believe the last time it not only was before this court, but I think the same panel, I'm pretty sure. This court issued a reversal in, I want to make sure, in June of 2017. And the reason this court reversed, I don't have to tell the court why it did it, but it said that the journal entry that was before it granting summary judgment was very thin, it was minimal, and specifically, I want to point out paragraph 11 and quote something this court wrote, that the judgment entry is devoid of any other legal analysis or reasoning. This court's opinion seemed to focus, I mean, certainly I think in summary judgment it's good to have some factual analysis, but this court seemed to issue an opinion saying, more specifically, how about some legal reasoning? It went back down, we had another summary judgment granted, and once again, another deja vu situation. You have a journal entry in front of you that has virtually no legal reasoning. It's as if the trial court didn't read your 2017 opinion. It has a little more facts discussed in the opinion, but as far as if this court wanted legal reasoning, as it said in its opinion, you're not getting it here. You get Drescher v. Burt and Civil Rule 56, which is probably in 99% of summary judgment orders in the state of Ohio. If you're looking for any law beyond that, you won't find it. And this case involves a lot of issues that don't come up all the time. Issues of selective enforcement. The law on that is not exactly black letter law, depending on how you view intentional torts. What is a special deputy? What is a commission? What are the incomes for someone who's working as law enforcement but not actually a peace officer? There's a lot of legal issues here. You're not going to find those legal issues really addressed in the summary judgment motion, aside from just some general discussion of, we know he's special commission and we think his payment came from a third party. There's no case law, there's no statute cited, there's no Ohio Administrative Code, any of the things that were raised in either my brief in opposition to summary judgment or any of the law and legal research that Prosecutor Sims put forward. Trial court didn't look at it, or if it looked at it, didn't concern it. In addition to the absence of legal reasoning, there is some discussion of facts. It's a few more pages than last time we were here. But the summary judgment order says, well, Mr. Schutte has a self-serving affidavit, and that's not good enough. Well, right, a self-serving affidavit isn't good enough, but there's a lot more to this case that isn't mentioned in the summary judgment order. I mean, there were 4 depositions done. Mr. Schutte did an affidavit and a deposition. Well, those are self-serving, fair enough. But you also have depositions of Deputy Hillis, you have DeSabato, and you have Sheriff Steve Bailey, who were deposed. You're not going to find any quotes from any of the depositions in the order. You're not going to find any of the testimony that they gave in that deposition. It's not in this order. I prefer to have the court decide this on the merits, but, and again, I don't know if law of the case doctrine applies here or not, but the court specifically asked the trial court to give it some legal reasoning for its summary judgment decision. You didn't have it last time, and you don't have it this time. That obviously goes to assignment error 1. That's a pretty long preamble I provided there. Assignments of error 2 and 3, go to the material substance of the claims, and I'll just group them as intentional torts and the wrongful termination. Both of these issues are, you might say, well, there's a lot of evidence against Mr. Schutte. Certainly that's true. But are there genuine issues of material fact as to he lost income? He lost revenue because his special commission was taken away. What's the law on that? Does that count as a wrongful termination claim? I don't think that's really decided. I don't think there's any black letter law, any clear precedent on that issue that I could find, and you certainly won't find it in the summary judgment opinion. And as to the intentional torts, it really reads more as a civil conspiracy claim, but of course that was not put in the complaint. I didn't draft the complaint, as the court knows. But you have potentially 8 different public officials who are talking about charging Robert Schutte with a 3rd-degree misdemeanor. Now, look, I was a municipal prosecutor long ago. 8 people investigating someone on a 3rd-degree misdemeanor, I think we could say that's unusual. And oh, by the way, these 8 individuals from different jurisdictions, right? City of Greene, Summit County, you have different lieutenants and sergeants all talking about whether or not to issue a 3rd-degree misdemeanor against Mr. Schutte. They talked about it for possibly 9 days. There's a deposition saying, yeah, we talked about it for potentially 9 days. Now, does that show an improper motive? Could a jury think that that suggests an improper motive in charging Mr. Schutte with a 3rd-degree misdemeanor? It could be a jury issue. What are the damages to that? What are the other elements of the offense? I mean, certainly there's issues here. There's no slam dunk case in this matter, but is there enough factual dispute that maybe we should have a jury trial and let a jury decide, was there improper motive? Certainly, could you say it's unusual to have eight law enforcement officials and law directors talking about issuing a 3rd-degree misdemeanor? I mean, you have a lot of felonies that don't receive this kind of attention. Why does Mr. Schutte garner this amount of investigation? If there are no questions as to the issues I put forth, I would reserve the balance of my time.
You'll be able to retain 5 minutes.
Thank you.
Thank you.
Good morning. My name is Maureen Sims. I am an assistant Summit County prosecutor, and I am representing the Summit County Sheriff's Office as well as Sheriff Steve Berry, Deputy Robert DeSabato, as representatives and employees of Summit County. With respect to the first issues raised by the appellant about the sufficiency of the second journal entry, I believe the journal entry only needs to be sufficient to permit appellate review, and I believe this journal entry is sufficient for the court to discern why the judge ruled in the manner he did. To kind of go along what a prior attorney said in the prior oral argument, it is difficult sometimes to prove a negative, and I believe that the brevity, if there is brevity in this journal entry, it is because the appellant does not have sufficient facts to show that he should proceed to trial on any of the claims in this matter. The judge notes that count 1 should be, motion for summary judgment should be granted on count 1 because the defendants are entitled to immunity. So he does not specifically state in the journal entry RC 2744, however, it is briefed on in my motion for summary judgment, and he indirectly refers to that section. Count 2, he notes, which is the selective enforcement, that the record is devoid of facts. I know Attorney Gallick talked about his prior employment and his opinion that taking 9 days to issue a ticket for a misdemeanor of a 3rd degree is unusual. However, that's not in the record, that was unusual due to the circumstances of this case, that we have 2 City of Green officials complaining to the Sheriff's Office about work being done on one of their public roads, so that's 2 of the officials. You have the deputy, you have the deputy supervisor, and due to the fact that he held a special commission, Sheriff Barry consulted not only with his attorney, but Major Brad Whitfield. So I don't believe there is anything in the record to show that this was an unusual event. And in addition, to prove selective enforcement, the evidence needs to be substantial. As the trial court noted, the record is devoid of any evidence showing selective enforcement. With respect to abuse of process, count 3, the trial court notes there are no operative facts. In the deposition, the plaintiff concedes he didn't know of any involvement that any of the county defendants had once the summons was delivered to him. Once this became filed in Barberton Municipal Court, it was handled by Assistant Prosecutor Holly Reese, who motioned the court, filed a pleading that they were discussing resolution with his attorney Barry Ward. No mention that the Sheriff's Office was involved in that case, which lasted for 6 months. And finally, count 4, what is clear from the deposition of Robert Schutte is that he was not an employee of the Summit County Sheriff's Office, and he hadn't been an employee for years prior to Steve Barry's decision to revoke his special commission. The documents corroborate this position, that he was employed outside. He at one point worked for Akron Public Schools. He was retired from Akron Public Schools. There are records that indicate he is not employed by the Summit County Sheriff's Office in the years prior to the revocation of his commission. And in fact, there are multiple documents that he's acknowledging that his commission is to be served without compensation. Lost income from other sources does not equate to employment, and the appellant has not set forth any legal basis to show that that is not correct, which is why count 4 fails in this case. And in conclusion, unless anyone has any questions, I do cite a case of State versus Jawan, beginning with a J, for the proposition that the trial court is not permitted to assume facts that are not on the record. So the trial court was confined to the evidence. He found that the county defendants set forth in their motion for summary judgment proof that there are no genuine issues of material fact, and the plaintiffs presented only conclusions and no meaningful facts to overcome what was asserted in the motion for summary judgment. I would ask that you affirm the judgment entry.
Counsel, with the trial court in the journal entry, I don't know, I guess it's a he, basically just said that the defendants had met their burden,
He did.
but he didn't really expound on that.
He did talk a little bit, I believe, on page 2 or page 3 of the journal entry. He talked about the specific counts, beginning on page of 3, about how the plaintiffs had failed to show that we were not immune.
Right, but the address your burden, is there a reciprocal burden, and before you even have a burden as the plaintiff or the non-moving party, the moving party has to demonstrate there's no issue of that.
Right, and he acknowledges that. Obviously, he could have been more detailed. Any journal entry could be more detailed.
Well, it's just a matter of what we said in our prior judgment, whether you agree with it or not, is what we said about, immunity, about all these different, legal theories and so forth, and we didn't have any analysis of that.
And my position would be the brevity of the journal entry, if you would think this is brief, would be due to the only conclusory opinions that were submitted by the plaintiff, making this journal as brief as it is, making the judgment entry as brief as it is.
Let me ask you a question. This is a de novo review, correct?
It is.
So is our de novo review, in your opinion, a de novo review of the facts of the case or a de novo review of the judgment entry that the trial court issued?
I think that is a very good question. In preparing for this oral argument, I thought of if it is possible for you, because this is a de novo review, to look at the motion, to look at the record that was put, and to find that the defendants have met their burden. I suppose when you look at your job as an appellate, would it be permitted for you to do so? Possibly. However, I think it would be best practice for the trial court to conduct a thorough review of the record. And then, but in your de novo review, it is as if you have to do the same review in order to make sure that the trial court's legal basis or multiple legal bases were proper.
Or the final resolution? Because there would be a difference. If it's a simple journal entry granting, based on the totality, whatever, I'm going to grant the summary judgment motion without any explication from the trial court. And then we did a separate de novo review, come with our own decision that did or did not comport with the simple thing that the trial court issued. I mean, how do you justify those things?
I do know at times you agree with trial courts in different cases for different reasons. So I guess theoretically, for example, a suppression motion is granted by the trial court and it's appealed. I know there have been times where the appellate court has agreed with the granting of the, or the denying of the suppression motion, but for different reasons. So I suppose you never know for sure whether you're agreeing with the trial court for the same reason or not. Is it necessary for you to be completely aware of the trial court's reasoning in granting the judgment? Is something I probably can't fully answer today. But I do think the trial judge in his entry seems to think the plaintiff has not set forth any evidence to show any of these counts. And if you go to that sort of reasoning, because I think you can from the journal entry, that there really is no evidence in the record, I suppose you would be, it wouldn't be beyond your role to look and see if you disagree with him. My position is you will look at that record and you will find there is no genuine issues. A 9-day time from the complaint to the issuing of a summons, a telephone call to pick up a summons for an excavated road is not close to being malicious prosecution. And I believe that the depositions cited by the plaintiff, although, again, it's an inference on an inference, I don't think they met their burden in this case, which reflects why the journal entry may not contain as much legal analysis as maybe a normal journal entry would contain.
What if the trial court had just said, you didn't meet your threshold burden and denied summary judgment? That's all it said.
I believe we may have, at least on the 3 counts, and I'd have to confer with my client as to whether we would appeal that or not, because I don't believe the unlawful termination immunity applies to count 4. But I think I have an argument that immunity applies to the first 3 counts. And so I suppose I would appeal.
It's hard to formulate how you would appeal. And they just say, no threshold burden.
And probably I would,
Rewrite the whole summary judgment motion over again in front of us.
there are no further questions, I thank you for your consideration. And I concede the rest of my time.
Thank you.
Judge.
You have 5 minutes.
Thank you. And Judge Carr, going to your question, I mean, obviously, this is one case, it's a small case, it's not a multi-million-dollar case, but as it often is, one case influences hundreds or thousands of others. And this court could say, you know what, we don't need any legal reasoning, because, you know, we're here on a de novo, Judge Schaefer, factual review to your question to Applee, and you're always under de novo legal review, so this court could issue a precedent and say, you know what, we don't care what you do on summary judgment, we're just gonna do everything, don't bother writing any kind of journal entry, just say granted, and we'll just do it from scratch. But what does that do to judicial economy? I mean, I think what the court was saying in its 2017 opinion is you'd like to have a little more to work with, so you don't have to start from square one on every single summary judgment case.
But we do have to start from square one on every single summary judgment case.
Well, but you know what?
We do have to start from square one on every single summary, but there's no well.
Your Honor, I know you have
That's what a de novo review is.
you have sua sponte ability. I could raise one assignment of error, and you could find 4 others and say we're gonna.
But we
you
still
could.
have to start from scratch.
Well, you know, if that really is the case, then the question becomes, what is the purpose of the trial judges all across the state writing all these summary judgment orders that are essentially meaningless? Do you know what I mean? They're writing this order, it doesn't matter, we're gonna come here, it doesn't matter what issues are raised or what legal analysis or factual analysis the trial court does, we're gonna start from scratch. It should be some sort of basis where the appellant looks at this and says, you know, the judge made a legal error here on this assignment of error. The judge made a factual analysis mistake here, so we can, even though this court has plenary authority to attack summary judgment, to narrow the focus and say, Your Honor, I want to direct your attention to, imagine if we were here right now where the trial court put out an issue on what malicious prosecution was. And we could argue, the trial court said malicious prosecution is this, based on this 3rd district opinion, based on the Supreme Court opinion, they're mistaken. Instead,
Certainly would be best practice.
it would be best practice. Instead, we're here saying, I think the trial court meant this. I bet the trial court didn't think the plaintiff had a good case. We're just guessing. And is that best from a judicial economy standpoint?
Well, I guess what my concern is, obviously it's always judicial economy, but, and I think that's what we tried to express in a prior opinion, but maybe we didn't do an adequate job. What if you decide a case on, let's say, statute of limitations and say summary judgment grant statute of limitations? It comes up and we say, no, statute of limitations wasn't, statute of limitations didn't preclude the judgment. However, there is immunity issue and we're gonna grant summary judgment on immunity. Then one party doesn't get the right to even appeal that.
Not by right. They can do a discretionary to the highest Supreme Court and see how that works out. I mean, that's certainly true. These are real issues as to how much sua sponte power the court wants to exercise. But certainly, I think this court in the 2017 opinion was read pretty clear to me. We'd like some legal analysis. I mean, you wanted some factual analysis. You specifically said legal reasoning, and you didn't get it. And so what should you do? I mean, send it back down and to the trial court and say, we really meant this. We're pleased. Maybe say please. You get it next on the 3rd time. I don't know. But I have to tell you one thing about the facts of the case. Not just that you have 9 days of them deciding whether or not to issue a 3rd-degree misdemeanor. Then you have, and this is in the depositions, that they spent various time talking about, we got to revoke his special commission because of this 3rd-degree felony. But then in Steve Barry's deposition, he said, well, it wouldn't matter, we would have revoked it anyway. You've got contradictory testimony within the depositions. None of that's mentioned in the summary judgment ruling. Prosecutor Sims mentions the DeJuan case about you can't assume facts not in the record. Obviously that's true, but you can't assume facts that are in the record. And there's many facts in these depositions that are mentioned in my brief in opposition that the trial court either didn't look at or didn't concern itself with, certainly didn't mention in its ruling. And you know that 3rd-degree misdemeanor was dismissed. I think this is in Mr. Barry or Sheriff Barry's deposition. They know it was dismissed. We can't get into why Holly Reese dismissed it. It was dismissed without prejudice. 2 years has long passed. It's not going to be recharged. So you have all of this discussion on maybe as many as 3 circumstances: to issue the charge, to revoke his commission, and then to dismiss the case. Could that be something you put in front of a jury? I say that it is, but it would be nice to know what legal basis the trial court had in saying it's not worth a jury's time. These raise larger issues. I mean, you know, I think that this court at a minimum should try and reassert what it said in its first opinion. I mean, what do you say? Just we're going to forget about this court's 2017 opinion? It was pretty clear. But at some point, these material issues are going to have to be resolved, but unfortunately, it might have to be in a third appeal, which is not good economy for the court or the litigants or anyone. So there's broader issues here, much larger than this case. If there's no further questions, I thank the court for its time.
Thank you. Thank you both for your presentations today. The court will take the matter under advisement and issue a decision which will be mailed to both sides as well as posted to our website and that of the Supreme Court.